Contempt is where a court orders someone to do something, the person fails to do it, and the court has remedies available to it to coerce that person to do what the court has ordered. And that is the goal of contempt. Civil contempt is coercion. So the remedies that a court has available to it for civil contempt are that it can fine the person, or it can incarcerate the person for failing to do that which the court has ordered. The theory being that the person has the power to get out of jail. They have the keys to their jail cell just by complying with the court's order. People are afraid of contempt of court as it pertains to asset protection because they hear stories that people set up offshore trusts and a court orders them to bring the assets back from the trust, and they don't do it and they get put in jail. Nothing could be further from the truth. It's not, that only happens where the trust has been improperly structured or where the person has retained too much power over the trust. The law with respect to civil contempt as it pertains to asset protection planning was set forth by the United States Supreme Court in 1948, and it hasn't changed since then. Although if you read articles and posts on the internet, one might think that as soon as you set up an offshore trust, you're headed for jail. The law of civil contempt is as follows. The U.S. Supreme Court, in the case of Maggio versus Zeitz, the 1948 case I just referred to, held that you cannot be held in contempt and incarcerated for failing to do something which you do not have the power to do, even if you created the impossibility. Because if you were to be incarcerated when something that the court has ordered you to do is impossible, that would just be punishment. It would not affect the goal of coercion, which is the goal of a contempt order. The Bellinger case was important in the area of contempt as it relates to asset protection planning because it proves that if a trust is properly drafted, properly implemented, and properly administered, that a settlor will not be held in contempt for failing to bring the assets back from the trust. Civil contempt is misunderstood because if a person happens to have an offshore trust and also is incarcerated for civil contempt, many people who write about these things put the two together as if one had something to do with the other. I'm personally aware of a case where a lady was incarcerated for civil contempt and she had an offshore trust. Many articles were written about that matter indicating that she was incarcerated because she had the offshore trust. The reason she was incarcerated, which I happen to know, is that she disobeyed a court order and left the jurisdiction. In citing as proof that you'll go to jail if you set up an offshore trust, many writers cite Lawrence and Anderson, two cases from the late 90s in which both the settlors went to jail. Neither of those cases is the same as the Bellinger case. In both Lawrence and in Anderson, the settlors, who were the creators of the trust, had complete control over their trusts. And that's why the court incarcerated them, as it was proper to do.